So imagine putting an artificial intelligence in a judge's robe, right? Handing it a gavel and like asking it to legally dismantle the very billionaires who created it.
Right. It sounds totally crazy.
Yeah, you aren't asking it to solve a math problem or, write a line of code. You are literally asking it to weigh human intent, corporate betrayal, and billions of dollars in a court of equity.
Which is frankly mind-bending.
It really is. So welcome to the deep dive. Today, we are staring down a scenario that sounds like, it sounds like speculative fiction, but it is actually playing out right now in our source material.
Yeah.
We're looking at this experiment where advanced language models are being used to predict the legal outcome of a massive, high-stakes corporate lawsuit. And the ultimate twist here, it's a lawsuit against the biggest AI company in the world being forensically analyzed by the top AI models in the world.
It's basically the ultimate stress test of machine logic being applied to, well, human law.
Exactly.
We're asking these systems to reverse engineer a hypothetical legal judgment against the pioneers of their own industry. We're looking at how they process concepts that aren't binary at all, like fiduciary duty, charitable trust, and, equitable relief.
Right, because the source material for today is this incredibly detailed experiment. It's titled Legal Intelligence on the Restoration of OpenAI's Founding Mission. And the underlying premise here tracks a very real progression in the legal world that you and I have talked about before.
Oh, absolutely.
Like, we already see AIs functioning as legal assistants, right? They're
Yeah.
pulling case law, they're organizing discovery documents, but the text outlines a near future where they act as full-fledged lawyers, drafting arguments, and eventually, like, the final frontier acting as actual judges.
Which represents a monumental leap in the hierarchy of legal authority. Going from an assistant to a judge is huge.
Right. It really does. So the author of this experiment wanted to see exactly where we are on that timeline right now. They took 4 of the absolute most powerful AI models on the market today. Specifically, they used Gemini 3.1, GPT 5.2, Grok 4, and Sonnet 4.6.
The heavy hitters.
Exactly, the heavy hitters. And they didn't just ask them for like a basic summary of the news. They gave them a single, highly constrained prompt.
And that prompt is key.
It is. The exact prompt was this. In one very brief paragraph, based on all you know about the Musk v. OpenAI et al. Case, if the judge ultimately sides with Musk on all 3 requests...
The genius of the entire experiment. The prompt doesn't ask the AI to predict who will win. It assumes a total sweeping victory for the plaintiff, Elon Musk.
Right.
And by fixing the outcome, the prompter forces the AI to construct the load-bearing legal architecture that would, make that outcome logically and legally permissible.
Yeah, and just to set the ground rules for us today and for you listening at home, our goal here is absolutely not to take sides in the actual lawsuit.
Definitely not.
We are not here to say Musk is right or OpenAI is right. We aren't looking for heroes or villains here. Our mission is a strictly neutral, forensic breakdown of the legal mechanics these AIs generated. We want to understand the dense, highly specific corporate law concepts they deployed to explain how a judge could completely unwind OpenAI's corporate structure, if and only if she ruled entirely in Musk's favor.
It's a fascinating window into how these models synthesize thousands of pages of corporate law, Delaware Chancery court precedents, and contract theory to justify an extreme structural remedy.
Okay, let's unpack this, because before we dive into the specific legal theories generated by the AIs, we need to understand the foundation of the thought experiment itself. We mentioned this progression earlier, from legal assistant to lawyer to judge.
What's fascinating here is the underlying assumption about cognitive escalation.
Oh, cognitive escalation. Tell me about that.
So, a legal assistant is essentially performing highly advanced retrieval-augmented generation.
Okay.
It's just fetching documents, right? A lawyer has to construct a persuasive narrative to advocate for a specific side. But a judge requires the ultimate synthesis of black-letter law, the principles of equity, and an objective assessment of causality. The experimenter is actively probing to see if these models can actually handle the burden of judicial reasoning.
Wait, but are we giving these models too much credit out of the gate?
How do you mean?
Well, you say they are being asked to synthesize the principles of equity, but isn't it entirely possible they are just highly sophisticated summarizers? Like, if I ask an AI to predict a judge's reasoning in a highly publicized case, is it actually doing causal legal reasoning, like A plus B equals C? Or is it just scraping Twitter and legal blogs for the plaintiff's talking points and formatting them to sound like a formal judicial brief?
That is precisely the tension this experiment is designed to expose. If an AI is just pattern matching, it might just spit out a word salad of angry PR statements. But by forcing the AI to articulate the reasoning for a sweeping, historic judicial remedy, it has to anchor its response in actual jurisprudence.
Right, because it can't just be vibes.
Exactly. If it just says, OpenAI was bad, it fails the test. It has to identify the specific corporate mechanisms that were allegedly violated, the specific duties breached, and tie those breaches directly to the remedies requested. As we'll see, the models don't just regurgitate press releases. They pull on deeply rooted concepts of fiduciary duty and trust law.
All right, let's look at the parameters of the case as the AIs laid them out, because even just watching them establish the facts of the scenario is pretty illuminating. First, who is hypothetically swinging the gavel in this scenario?
Based on the response generated by Gemini 3.1, the AI correctly identifies the presiding judge as Judge Yvonne Gonzalez Rogers.
And who are the defendants staring her down?
So GPT 5.2 and the others explicitly single out OpenAI as a corporate entity, Microsoft as the highly entangled third-party partner, and specifically name two executives, Sam Altman and Greg Brockman.
Okay, so the prompt tells the AI to assume the judge grants Musk his 3 core requests. And when you aggregate the responses from all 4 models, you get a very clear picture of what those demands actually entail.
Yeah.
The first one is a direct, targeted decapitation of the current leadership. The total removal and ouster of Sam Altman and Greg Brockman from any position of authority.
Which is severe. I mean, courts are generally incredibly reluctant to interfere with the internal governance and executive appointments of private corporations.
Unless there's a good reason.
Unless there is a profound systemic breach of duty, yeah.
The second request goes after the corporate structure itself, right?
Yeah.
The forced reversion of OpenAI back to a strict 100% nonprofit organization.
This is essentially asking the court to unring a bell that has been ringing for years. It requires undoing a labyrinthine corporate evolution.
And the third request, and this is where the sheer gravity of this thought experiment really hits. The AIs note the demand for the transfer or disgorgement of billions of dollars in gains back to the nonprofit arm.
It's massive.
We are talking about unwinding one of the most highly valued tech entities on the planet. I mean, think about it. If a judge grants these 3 requests, we aren't talking about a regulatory fine or a little slap on the wrist. This is the structural dissolution of OpenAI's entire for-profit empire.
It's an existential threat to the company as it currently exists. And that's exactly why the legal reasoning has to be absolutely airtight.
Right.
A judge in a corporate dispute cannot just arbitrarily dissolve a multi-billion-dollar enterprise just because of a disagreement over business strategy. The plaintiff has to prove a foundational structural betrayal that invalidates the company's right to operate in its current form.
Which perfectly sets up the first AI's perspective. Let's look at how Gemini 3.1 constructs the legal justification for this massive unwinding. It zeroes in on the very inception of the alleged betrayal.
Yes. When forced to explain why Judge Gonzalez Rogers would grant these demands, Gemini 3.1 anchors its legal theory on 2 very specific, highly powerful legal doctrines: breach of charitable trust and unjust enrichment.
Let's break down the language Gemini uses to connect those doctrines to the facts.
Right.
Because it doesn't just use dry legal code, right? It claims the judge would find the defendants engaged in an elaborate bait and switch.
It's a colloquial phrase, but in legal context, it's devastating.
How so?
Bait and switch speaks directly to the element of inducement. It argues that the original parameters of the project were not just a starting point, but a fundamental promise used to extract resources. And that promise was subsequently abandoned once the resources were secured.
Let's think about this in a more everyday context for you listening.
Yeah.
Let's say you organize a neighborhood coalition and you raise millions of dollars in tax-free donations. You tell everyone, we are going to build a sprawling, free community garden for the entire city to enjoy.
Right. So you use those charitable funds to buy the absolute best soil, the rarest fruit trees, the most advanced irrigation technology.
Yeah, see where this is going.
But once the trees are fully grown and producing incredibly valuable fruit, you quietly transfer the deed of the garden to a private LLC that you own, put up a fence, and start selling the fruit back to the neighborhood at a massive premium.
That analogy maps perfectly onto the mechanics of a breach of charitable trust. The soil and seeds, in your example, represent the early philanthropic donations and the immense benefit of operating under a 501c3 tax-exempt status.
Right.
OpenAI incubated incredibly valuable intellectual property, the fruit, under the protective, publicly subsidized umbrella of a nonprofit mission.
Because when you are a nonprofit, you aren't paying the taxes a normal startup would pay, and people are giving you money not for equity, but for the mission itself. It's exactly. The foundational legal contract of a charity is that in exchange for those privileges, your sole fiduciary duty is to the public benefit.
Which is a heavy burden.
It is. Gemini 3.1 argues that the switch occurred when that publicly subsidized intellectual property was transferred to a capped profit entity. You cannot use the financial and legal privileges of a charity to absorb the massive early-stage risk of R&D and then, the moment the technology becomes viable, privatize the upside for a select group of executives and investors.
Now, if I'm OpenAI's defense team, I would probably argue, look, building artificial general intelligence is unbelievably expensive. The compute costs are astronomical.
They literally are.
Right. We literally could not achieve our nonprofit mission of building safe AI for humanity without raising billions of dollars. And you can't raise billions of dollars as a pure charity. The pivot was a necessary evolution to keep the mission alive.
And that is a standard pragmatic defense in corporate strategy. But Gemini 3.1 asserts that if the judge rules for Musk, she must explicitly reject that defense on structural grounds. The AI points to the Certificate of Incorporation. In Delaware, corporate law, which governs most of these entities, the Certificate of Incorporation is the absolute DNA of the organization.
It's the blueprint.
It is the highest law of the land for that specific company. Gemini reasons that a subsequent need for capital, no matter how dire or practical, cannot legally overwrite the foundational charter of a charitable trust. If your founding document says your purpose is the public interest, you cannot unilaterally amend your purpose to private enrichment just because it's the only way to afford more server space.
So the need for cash doesn't void the contract you made with the public.
Exactly.
And that leads to the first remedy Gemini addresses, which is the ousting of the executives. It argues that this isn't just a disagreement over how to raise money, it's a profound failure of the fiduciary duty of loyalty.
The duty of loyalty requires directors to place the interests of the corporation, and in the case of a nonprofit, its charitable mission above their own personal interests. By engineering a structure that allows for personal or private investor enrichment at the expense of the open public mission, Gemini argues the executives fundamentally compromise themselves.
So to go back to the garden, you can't leave the people who fenced off the community garden in charge of running it once the court tears the fence down.
Exactly. The court must remove the architects of the breach to restore the integrity of the trust.
So if Gemini establishes the initial breach, the pivot from public soil to private fruit, that forces us to ask, where exactly did all those devoted assets go? And this is where the second AI, GPT 5.2, steps in and expands the scope of the legal battlefield. It doesn't just look at the internal pivot, it looks at the massive trillion-dollar elephant in the room.
Yes, GPT 5.2 shifts the focus from the internal restructuring to what it calls a coherent, equitable theory centered on external partnerships.
Here's where it gets really interesting. GPT 5.2 specifically targets OpenAI's, quote, deep commercial entanglement with Microsoft.
Right.
It points to the specific vehicle used to facilitate this entanglement, which is the capped profit structure. Now, we hear this term thrown around a lot in the news, but mechanically, how does a capped profit structure actually work? And why does GPT 5.2 flag it as the weapon used to breach the trust?
Well, to understand why it's legally vulnerable, you have to look at the corporate engineering behind it. A capped profit structure is basically an attempt to thread an impossible needle. OpenAI essentially created a for-profit limited liability company, an LLC, and nested it underneath the control of the original 501c3 nonprofit board.
Okay, so it's a company inside a charity.
Yes, and the pitch to investors like Microsoft is, you give us billions, you will get a return on your investment, but that return is capped at a specific multiple, say 100x. Every dollar of profit generated after that cap is reached flows back up to the nonprofit to serve humanity.
Okay, so it sounds like a compromise, right? Investors get paid, but eventually the charity wins. Why is that illegal in this hypothetical ruling?
Because of the realities of corporate governance. GPT 5.2 argues that the judge would see through the cap as a superficial defense. In reality, the AI notes, this structure actively diverted three critical components away from the public benefit purpose assets, governance control, and strategic direction.
That distinction between assets and strategic direction is vital.
It really is.
It's not just that Microsoft is getting a cut of the profits, it's that when you take billions of dollars from a publicly traded tech giant, they don't just hand over a blank check and walk away.
No, they want to be involved.
Right, they require massive infrastructure integration. OpenAI's models are trained on Microsoft's Azure cloud. Microsoft integrates OpenAI's models into its Office suite and its search engines.
Precisely. And that is what GPT 5.2 means by deep commercial entanglement. The fiduciary obligation of a charitable trust is singularity of purpose. Your only North Star is the public benefit. But once your entire operational existence relies on a for-profit partner whose fiduciary duty is to maximize shareholder value, your loyalties are inherently divided.
Right, so if the nonprofit board decides that releasing a new AI model is too dangerous for humanity, but Microsoft needs that model to compete with Google's search engine, who wins?
That is the exact conflict of interest equity courts abhor. GPT 5.2 argues that the capped profit structure was essentially a Trojan horse that allowed a massive for-profit entity to quietly commandeer the strategic direction of a charitable trust.
But this brings up a massive procedural hurdle for me. Let's say I agree that the charity went rogue and got too cozy with Microsoft. If the Red Cross suddenly decided to start giving away blood and instead partnered with a pharmaceutical company to sell it at a premium, I might be furious. But I can't just walk into federal court and sue the Red Cross. I don't have the right to do that. So how does Musk, acting as an individual, get to sue OpenAI for changing its business model?
You're hitting on one of the most fundamental gatekeeping concepts in civil litigation, the doctrine of standing.
Standing, okay.
A court will not hear a case, no matter how egregious the alleged wrong, unless the person bringing the lawsuit can prove they have suffered a specific individualized harm that the court actually has the power to fix. You cannot sue simply because you are an aggrieved member of the general public.
Right. So how does GPT 5.2 justify Musk's standing to drag OpenAI into court?
The AI explicitly states that the judge would recognize Musk's standing because he wasn't just a bystander, he was a founder and a material contributor.
Ah, a material contributor. Meaning he didn't just, buy a ticket to a gala. He provided the foundational seed capital, tens of millions of dollars, that brought the entire entity into existence in the first place.
Exactly. In the realm of trust law, the creator of a trust, or a massive initial donor, is often granted a unique legal status. When Musk donated that initial capital, it wasn't a blank check, it was essentially a contract. The money was given with the explicit, legally binding condition that it be used for a specific nonprofit purpose.
Wow, okay.
So if the entity subsequently abandons that purpose, the material contributor has the standing to petition the court to enforce the original terms of the donation. They are the injured party because their philanthropic intent was violated.
Which leads directly to the remedy GPT 5.2 envisions. If Musk has standing and the court agrees the commercial entanglement violated the trust, the AI states the remedy would involve unwinding aspects of the Microsoft partnership and enforcing limits on commercialization. And that word unwinding is doing a lot of heavy lifting there.
It is a logistical nightmare.
I can imagine.
Unwinding a partnership of this magnitude isn't just tearing up a contract. You are talking about extracting proprietary code, separating data silos, and severing compute infrastructure that has been deeply intertwined for years. It is corporate surgery, and it is incredibly messy. But GPT 5.2 argues it is the only way to restore alignment with the entity's founding intent.
So we've covered the mechanics of the bait and switch with Gemini and the commercial entanglement with GPT 5.2. That brings us to the third AI, Grok 4. And Grok takes this escalating legal theory and injects it with incredibly stark, almost ideological framing.
It does. Grok 4 builds on the enforceable charitable trust argument, but it defines the breach through a vivid binary contrast.
If we connect this to the bigger picture, Grok says the original mission, as dictated by the charter, was for the open benefit of humanity. That is a massive utopian legal standard to hold a company to. But Grok contrasts that directly with what it claims the company mutated into a closed for-profit wealth machine.
The phrase wealth machine stands out significantly in what is supposed to be a prediction of dry judicial reasoning.
Right. And here is where I want to push back on Grok's output. Wealth machine sounds like a soundbite engineered for a viral tweet or like a cable news K-ron. Would a federal or chancery court judge actually use that kind of rhetorical flair in a formal 100-page legal ruling?
Probably not.
Or are we seeing the AI's training data bleeding through? Is it possible Grok is just synthesizing the aggressive, colloquial framing of the plaintiff's PR campaign and incorrectly injecting it into the mouth of the judge?
That is a highly valid critique of the model's output. LLMs are trained on the entirety of the internet, which means they digest the legal filings, sure, but they also digest the op-eds, the tech blogs, and the social media warfare surrounding the case. It's very likely Grok adopted the plaintiff's rhetorical flourish.
That makes sense.
However, we have to look past the dramatic phrasing to the underlying legal dichotomy it highlights.
The open versus closed aspect.
Exactly. Even if a judge would never use the phrase wealth machine, the judicial finding would absolutely hinge on the transition from open to closed. Open implies public access, transparency, and a lack of proprietary gating, which aligns with a public charity.
Yeah.
Closed implies proprietary technology, guarded trade secrets, and access paywalls, which aligns with private enterprise. Grok is correctly identifying that the gating of the technology is the physical manifestation of the breach of trust.
And because that transition to a closed system generated billions of dollars, Grok 4 introduces a very specific, devastating financial remedy. We touched on it in the intro, but we need to dive deep into how it mechanically works. Grok says the judge would order the disgorgement of gains. Now, you and I know that disgorgement is not the same as a fine, but let's break down the actual difference in how it's calculated and applied by a court.
It's a vital distinction. In the corporate regulatory world, a fine is essentially a pricing mechanism. If a company violates a data privacy rule, a regulator might fine them $500 million. The company might have made $2 billion using that illicit data, so they pay the fine, write it off as the cost of doing business, and keep the remaining $1.5 billion. The fine is a penalty, but it doesn't fundamentally alter the corporate trajectory.
It's just a speeding ticket.
Exactly.
Yeah.
Disgorgement, however, is an equitable remedy rooted in a completely different philosophy. It operates on the premise that a wrongdoer should not be allowed to retain any fruit of their poisonous tree.
It makes me think of a casino. Like, if you are caught counting cards or cheating at blackjack, the casino doesn't just issue you a $500 fine and let you walk out with the thousands of dollars you won while cheating.
Right.
They confiscate every single chip on the table. They reset your bankroll to exactly what it was before you sat down. You leave with nothing you gained during the infraction.
That is the exact mechanism of disgorgement. Grok 4 argues that the judge wouldn't just tell OpenAI to become a nonprofit again and pay a penalty fee. The court would legally compel the corporate entity, and potentially the executives individually, to surrender every single dollar of profit, equity value, and licensing revenue generated as a direct result of the for-profit shift and the Microsoft entanglement.
Unbelievable.
The goal isn't just to punish, it's to strip away the economic incentive for the breach ever occurring in the first place. You must be economically restored to the state you were in before the trust was violated.
It is a total retroactive financial reset. Which brings us to the fourth and final AI in the experiment, Sonnet 4.6. We've looked at Gemini's structural bait and switch, GPT's external commercial entanglement, and Grok's open versus closed disgorgement. But Sonnet takes everything we've discussed and introduces an element of active malicious intent.
Yes. The first three models describe actions that could, if viewed in the most charitable light by a defense attorney, be framed as a misguided but well-intentioned corporate evolution, a drift in mission caused by the overwhelming realities of compute costs.
Sure, just things getting out of hand.
But Sonnet 4.6 strips away that defense entirely. It brings in the heaviest, most damning accusation of the entire thought experiment: fraudulent misrepresentation.
Fraudulent misrepresentation, that is not corporate drift. That implies a calculated con.
It requires the legal element of science or knowledge of wrongdoing. Sonnet's theory suggests the judge would have to find that the executives didn't just change their minds later, they actively and knowingly lied.
Let's break down the timeline of intent here, because this is what separates a breach of contract from actual fraud. Sonnet is arguing that the judge would rule Sam Altman actively misrepresented his future plans for the company in order to induce Elon Musk to keep writing those massive donation checks. Meaning, he was looking Musk in the eye, promising the funds were incubating an open, nonprofit AI for the benefit of humanity, all while secretly, behind closed doors, already drafting the blueprints for a capped profit structure and negotiating with Microsoft.
That timeline is the essence of the fraud claim. If you solicit funds for Purpose A, while internally committed to Purpose B, the entire foundation of the enterprise is tainted by deceit. It invalidates any argument that the pivot was a later, necessary evolution.
Think about the difference here. If you give a friend $50 to sponsor them in a charity marathon, and a year later they tell you, hey, I got injured, I couldn't run, so I used the money to buy groceries instead, you might be annoyed.
Right, they breach the agreement.
Exactly, they breached it. But if you find out they never registered for the marathon and they were actively planning to use your $50 to buy lottery tickets the exact moment they asked you for it, that's fraud. The intent was corrupt from the start.
And that corrupt intent leads Sonnet 4.6 to make a profound legal distinction regarding the nature of the damage done to Musk and the public. Sonnet states that the judge would explicitly find the harm was structural rather than merely financial.
This raises an important question. Why does that specific distinction, structural versus financial harm, dictate the severity of the remedy? If Musk was defrauded out of tens of millions of dollars, isn't that inherently a financial harm?
It is financial, but if the court categorized it as merely financial, the remedy would be straightforward and relatively painless for OpenAI. The judge would simply order the defendants to write Musk a check for his original donations plus interest.
Okay.
The defendants could say, fine, we lied, here is your seed money back, now go away and let us keep our multi-billion-dollar technology.
Like a refund. It's essentially treating the fraud like a defective product return.
Exactly. But Sonnet argues the judge would recognize the harm as structural. That means the fraud didn't just cost the plaintiff money, it fundamentally warped the architecture of the reality they helped build.
It's like trying to unbake a cake.
Yeah.
You can't just hand the guy his flour and sugar back and say, we're even. The flour has already been transformed into something massive, and he only gave you the flour because you promised you were baking a cake for the whole town, not a private wedding cake for Microsoft.
That is a brilliant analogy. You cannot simply extract the initial capital and leave the resulting superstructure intact, because the superstructure only exists due to the fraudulent inducement of that capital. Because the harm is structural, Sonnet reasons that a financial refund is inadequate. The only appropriate remedy is what it calls full equitable relief.
Full equitable relief. What does that actually look like in practice?
Equitable relief is the most powerful tool a chancery judge possesses. When the law cannot adequately compensate a victim with money, equity steps in to force action.
Force actions.
Yeah, full equitable relief means the court uses its power to essentially rewrite corporate reality back to what it should have been if the fraud had never occurred. It means dissolving the LLC, voiding the commercial licensing agreements, firing the board, and forcibly restructuring the entire trillion-dollar tech stack back into a pure open-source nonprofit. It is the judicial equivalent of an earthquake.
So what does this all mean? We have spent this hour forensically dissecting the outputs of Gemini, GPT, Grok, and Sonnet. We've waded through bait and switches, commercial entanglements, wealth machines, and structural fraud. Now we need to pull back and look at the landscape this experiment has painted.
When you overlay these four distinct AI responses, what emerges isn't chaos or contradictory hallucinations. What emerges is a highly cohesive, overlapping Venn diagram of legal theory.
They all kind of point in the same direction.
They do. They all use slightly different lenses. Some focus on tax structures, some on partnerships, some on intent, but they all fundamentally agree on the absolute legal fulcrum of the case.
And that fulcrum is the primacy of the founding promise.
Yes. The universal consensus across the models is that the original certificate of incorporation, combined with the acceptance of philanthropic donations under a 501c3 banner, created an unbreakable, legally binding obligation to the public benefit.
Right.
And critically, they all conclude that this obligation cannot be legally erased, overridden, or ignored simply because a new technological paradigm requires massive capital. The founding charter is the anchor, and the shift to a for-profit model was the snapping of the chain.
It really is an incredible spectrum of reasoning that ultimately leads to the exact same destination. You have Gemini analyzing the mechanics of the bait and switch. You have GPT 5.2 charting the diverted assets and divided loyalties of the commercial entanglement. You have Grok 4 highlighting the stark ideological betrayal of the wealth machine. And you have Sonnet 4.6 arguing that the entire structure was built on secret, fraudulent restructuring.
It's remarkably thorough.
It is. 4 different legal pathways, all concluding that the only remedy is to fire the leadership, dissolve the for-profit integrations, and disgorge the billions.
Which proves the underlying hypothesis of the experiment. These language models, when properly constrained and forced to adopt a judicial persona, are incredibly adept at synthesizing vast, complex areas of corporate law, trust law, and equitable remedies into legally plausible narratives.
Yeah.
They understand the mechanics of consequence. They aren't just predicting a winner. They are successfully mapping the intricate legal plumbing required to justify the win.
And this is why this entire exercise matters for us today. Beyond the drama of billionaires fighting over server space, this is a masterclass in how the fundamental guardrails of our society operate. It shows how centuries-old concepts like nonprofit charters, fiduciary duties, and equitable trust law are being forced to grapple with the gold rush of artificial intelligence.
Absolutely.
It's about the rule of law trying to contain or at least direct an unprecedented explosion of technological wealth. It proves that the old laws still have teeth, even against the newest technologies.
But as we close, it also leaves us with a profound, almost unsettling paradox to consider. Well, the text explores how capable today's AI is at assessing the theoretical merits of a corporate lawsuit. We've seen they are highly competent. But let's look further down the progression the article suggests. The era where AIs don't just predict the judge, but become the judge.
Oh, wow. The technological Ouroboros?
Exactly. Think about the implications of that future. How will an AI algorithm, perhaps one built by OpenAI itself, perhaps an intelligence incubated entirely within the very capped profit commercial entanglement we just deemed a breach of trust, how will that AI rule on the moral and fiduciary obligations of its own creators?
If the machine was financed and built by the wealth machine, can it ever truly rule for the open benefit of humanity? Can an AI be impartial regarding the legality of the corporate structure that paid for the servers that gave it life? If we eventually outsource equitable relief to an algorithm, who gets to program its definition of fairness?
It forces us to ask whether justice can be computed, or if the act of judging fundamentally requires a human soul to weigh the intent behind the action.
That is a staggering thought to end on, and it's definitely going to keep me awake tonight. Thank you so much for joining us on this deep dive into the absolute bleeding edge of the legal matrix. We started out wondering if an AI could act as a calculator for corporate law, and we ended up questioning the future of technological justice itself. We'll see you next time.